and emails, which was helpful, but
We are live.
more than I needed to know.
TMI, they call it.
Yeah. Anyhow, I think it was concerned, but if you want to go back over. or-
Well, I really just want to note one technical change that I forgot to mention earlier, the technical fix that this committee should make. So good morning, Eric Fitzpatrick with the Office of Legislative Counsel. Excuse me, to talk with the. Starting on the right foot this morning.
Oh.
You can tell it's
We're all
Friday.
having a rough
Are we all right here?
We're all having a rough morning.
Yes. Excuse me. So talking with the committee about Senate Bill number 33, which is the annual miscellaneous bill. Committee spoke about this is the House changes to the Senate version of the bill, which the committee started to discuss earlier in the week. One point that I had forgotten to make is that you may recall, and this change was already made in S4, but this has to do with the change to conform with the Congressional Bipartisan Safer Communities Act to be able to report information on juveniles to the National Institute of Criminal Background Check when a firearm is purchased. So it's on page 14 of the bill you're looking at now. But just to be consistent, you remember, and it's line 9, this version still says age under 21.
Yeah,
It needs to say under 22.
right.
Because the records in Vermont, because the youthful offender status can go through age 21, under 22 would be correct to get them the right records. And not only that, but if this section passes in 2 different bills, you want it to be the same. Otherwise, it's
Where is, by the way, where is S33?
it is I'm going into House Ways and Means on it this afternoon because of the small claims fee. Same thing happened in Senate Finance.
That's right, yep. So it hasn't even, not even on the notice calendar.
Right.
Jesus Christ, they have given us little time to do anything. Very frustrating. Very frustrating.
After that one, I believe that just to sort of go up to the changes that the new sections that were added in the House start on
Yeah.
page 24.
Right.
And I think that the committee was okay with sections 29 and 30, 29 being the sexual exploitation of the person investigated, detained, et cetera. Section 30 being the tobacco products. Section 31 was the first one, I think, where the committee had indicated this had to do with the implied consent.
Yeah, I
blood
know.
test.
I don't think we want to deal with that issue. It's a bill that should be dealt with. I believe I asked you for a drafting request. Even
Yes.
if I don't support it. I don't know if I support it or do, but anytime we're talking about taking implied consent and sort of stuff, I think we need it as a regular bill to deal with. I may vote against my own bill, but I have no problem having the discussion.
Sounds good. I can put in the draft request for next year, certainly. So that was section 31, I believe.
Yeah, section 32, I don't think we had a problem with.
I think there was some
Oh,
discussion.
no, I
about-
think we did. I think
Oh,
we had
right,
questions.
it
This
should
was
be
the
correct.
the firearms in hospitals. I think we
Yeah.
had corrections
Yeah,
or
they-
questions,
I have a number of questions about that section.
like the out-of-state law enforcement officer I have flagged, the corrections
Yeah.
officer I have flagged.
Even security guards,
Yeah.
I'm not sure they're often trained in firearm safety.
Well, they have to, that's phrased, the Secretary of State has a firearm certification for security guards and private
Oh.
investigators, so they have to have received that certification. See lines 16 and 17 there.
Who was pushing for this? You know?
I believe this was a, H-172 was what the bill was as introduced, and I think that was representative of the.
Why is there a concern about out-of-state law enforcement? Because it's
It
pretty,
was Philip's concern, so I don't want to speak for
Okay.
him.
yeah, I mean, it's definitely not uncommon. I mean, they're, at least, with BMH, when I was down south and, mass troopers coming up for, let's say, a pursuit that came into Vermont, or if I was up Dartmouth, right on the border with New Hampshire and Vermont, and, DUI crash, and, I'd go to Dartmouth to do my thing. And so, it's just this reciprocation of state licensure, which I don't really think is, at least for me, it's not a concern. But
Yeah, I just flagged the concerns but I don't want to speak for Senator Brewer.
Yeah.
Well, let the House pass the bill and we'll take it up.
Right.
Take it out, please.
Take it out or up?
Out.
Oh, right.
Since it's already a bill in the House, let them pass the bill. And then I'm more than willing to take it up, and have a discussion.
Sounds good. So that means, so that's 31 and 32 will come out in the House, sorry, the Senate proposal amendment. That brings us to page 28, line 13, over on to page 29. This is just the, a repeat of the raise the age extension to 2024. I think that the Senate House put this in.
Isn't that in S4?
Yes,
We'll take it out.
sounds good.
They want the extension, they can pass S4 as we want. If I'm gonna put S4 into this bill and put all of what we want of S4 into it, not just the pieces they like.
Right. Plus, if you put S4 into the bill, then you'd have, those sections would be in there twice.
Yeah, then we'd have an agreement on
That's a
it.
waste of paper.
Um,
So that takes you over to section 36.
Actually, you take me out 35 too.
Yeah, that's all part of the
Oh,
same
okay.
thing, but the raise the age pieces, those two sections. That is part of another bill, H27, and this is, you may have heard about this, I can't recall if this topic has come up in the committee or not. This is the, asked for by the Center for Crime Victim Services, has to do with the existing RFA process. So when relief from abuse orders, generally speaking, have to be served on the defendant, right? So they have notice of it, they have to be served. There's an exception, though, that sometimes applies when the defendant is in court for the hearing. Because if you think about it, if they're in court physically present for the hearing, there's no need to pay a sheriff to physically serve them because they're right there for the hearing. They can just hand them a copy of the order at the hearing. However, with the advent of more Zoom hearings, the physical presence requirement has resulted in people being present at hearings over Zoom, getting notice of the order, and yet still having to be physically served by the sheriff for the order. So the proposal from the Center for Crime Victim Services is to say that if the person is present at the hearing, then the order can be mailed to them rather than personally served by the defendant.
They did a bill on that?
It was only part of the bill. The rest of the bill didn't go anywhere.
Okay,
Right.
I was just wondering. Sounds like a pretty, as you explained, it's just cutting down on the need to mail stuff.
Right, exactly. The service requirement.
I'm
So-
always trying to be helpful for the, save money for the state judiciary in terms of mailings.
All right, so that one stays in other words, section 36.
Section 37,
This one was actually part of a Senate bill. This is part of
Yeah, I know.
S27.
somebody got that in there.
Somebody did.
I wonder who.
It's hard to know.
The only change I'm sure you're probably more familiar with I didn't draft the Senate bill myself, but I can say that there's a slight change to the Senate bill language. And that is that it's on line 10 through 12. And the way the Senate language had been framed, it was that the Sentencing Commission would recommend the elimination of cash bail. The House committee didn't want to sort of presuppose the answer to that question and wanted the Sentencing Committee to recommend, and see it's phrased on line 10.
I know that,
Whether cash bail should be eliminated.
which I would rather see the Senate language in here than this, but
Well, we can change. If you want to change it, we can change.
I would love to put our language in.
That's part of our amendment.
All right.
Absolutely, your call.
Wonderful.
Just add that to our amendment.
Right.
If it's okay with Senator Sheen, I'm okay with it.
Kind of on the fence about it. I think kind of like what was mentioned, it presupposes the question to say a recommendation to end cash bail. I mean, that was the Senate language, right?
Yes, that was the,
Well, it was the bill language.
yes.
Yeah,
Well, it was what we passed out of
We
here,
passed
yeah.
out of committee.
yeah.
This committee? I must not understand it. Must be somebody else who wrote it.
It was the language that was in S-27,
Great.
that is on the wall now in the House.
Oh, I see. It just was probably Ben or Michelle who worked on it.
Ah, got it.
Yeah, I think it was Ben.
Great.
Yeah, not the end of the world, but it's just,
We had a lot of conversation about it. I would just rather see the language we passed out.
yeah.
So that was easy.
That
Yeah.
was easy. Was that all we're doing this
No,
morning?
Now, do you want to do Senator Sears, though, speaking of the
I
amendment?
wanted to go over S4.
Right.
Passed by the House Judiciary Committee
Yeah.
yesterday.
So would you think, though, I'm thinking of an S-33 amendment strike all, or
No, I would just amend with certain numbers of amendments.
the sections that you did?
The sections that, the little change in bail, the small,
Yeah,
the
yeah.
removal of the
Couple of
section on
sections.
implied consent, the
Yeah.
removal of something else, I can't,
The other one was the
all of the.
firearms in hospital.
Yeah, and the S4 stuff.
Put that in,
Well, if we're gonna
Oh,
do,
take out
if we're
that
gonna
stuff,
put
right.
S4 into S33,
right?
and we put it all in, not a little bit of it.
Yeah.
That's just my concern is the administration really wants to delay, raise the age. So you put that in this bill, in S33 as well as S4, and they get what they want either way, right? And so my concern is that S4 not pass. What you have also is an email from the state attorneys of their concerns with the new language, and Marshall is here to give his concern for the new language or lack thereof that's in the bill. But if we could start from the beginning. Section 1 is all the Big 12 and has our additions to those crimes that we found, such as aggravated murder, things like that. They've gone along with that. Section 1B1. What is that, Eric? Actually, 2A, I guess, is the new language.
I'm trying to pull up the documents. I don't have it in front of me right now.
That was the compromise I tried to offer, but they further compromised it.
Right, so the compromise is, you may recall that this has to do with the issue of whether or not new offenses should be added to the Big 12.
Right.
And so the Senate added a few offenses,
Right.
including, there were several, but one of them was the offense of carrying a firearm while committing a felony. And what the House did was, rather than add new offenses to the Big 12, for the most part, they took those ones, including carrying a firearm while committing a felony, and added them to the Sentencing Commission, or sorry, Justice Oversight Committee's study. Maybe it is Sentencing Commission, I'm sure I'm getting them mixed up. In any event, they put them in the study. So the proposal that Senator Sears has here is to say, all right, at least with respect to that offense, leave the other ones in the study. But this one, carrying a firearm while committing a felony, you would piggyback this onto the existing procedure. You may recall this, that under existing law, of course, Big 12 crimes have to be filed in the criminal division. They have to start there. Non-Big 12 felonies can be moved from the family division to the criminal division on motion, right? And that's existing B1. So if you're looking at your language B1, that's the process under existing law where For one of those non-Big 12 felonies, the state's attorney can file a motion, the court has a hearing, and they decide whether or not to transfer this non-Big 12 felony up to the criminal division. They can say yes, transfer, or no, stays in family division. And if looking existing law just for a moment, it's helpful. Look a little bit further down to subsection C. That's all, other than the underlying language, that's the existing procedures that are required for that hearing, right? Court has to make a determination as to C1, whether there's probable cause to believe the child committed the offense. 2, whether public safety and the interests of the community would not be served by treatment of the child in the family division. And then D says, all right, in making that determination, the court has to consider, and there's a long list of factors. I think there's 13 factors, various factors about the offense, about the youth, about the life circumstances. All those things have to be taken into account for this hearing. Now, that's all existing law, has to be done on motion of the state's attorney to transfer from the family division up to the criminal division. So what's the new provision? This says, well, for this one particular offense, now we're at B2, the new stuff, for this new offense that in the Senate version of the bill had been added to the Big 12 and which the House took out, you're looking for a middle ground. And the middle ground is, okay, for those offenses, there's going to be an automatic hearing. Won't automatically be in criminal division, but you will require that it's, rather than having the state's attorney have to file a motion for the hearing, for that offense, they'll have a hearing. It says family division shall hold the hearing, and the hearing will be to determine whether or not jurisdiction should be transferred. So it'll piggyback on the
And that was
existing.
your compromise?
Yeah,
That seems really reasonable to me.
Where,
well, they didn't accept it.
Oh.
They-
where are
we
you
can-
right now? On which page?
Page
Page
3,
3, if you look at 1,
B1 and 2, right?
2A and little I, the child is attained 16 years of age, but not 19. And was at the time of the act alleged to have occurred at the time of the alleged act. And then B requires the hearing as soon as practical, and the court decides whether it should be an adult or juvenile.
And so it got raised from 14 to 16.
I just took off 15. I would took off 12, 13, 14, 15.
Okay.
Okay,
They can be done still.
but it
under
wouldn't be
current
automatic.
law, but the Bennington State Attorney said he's had cases that lasted 11 months to get the transfer here. I don't know if that's common or not. I'm not sure. Not common.
No, I think Bennington has always had a very different scheduling experience than the rest of the state. Scheduling cases down there for whatever reason.
Probably partly because we don't have any judges that live there.
I think that is actually part of the problem, is there's lack of judges down there, but it doesn't take 11 months to get to a transfer.
But
hearing.
at any rate, the idea was that any crime where the person 16, 17, or 18 is carrying a firearm, that's a felony, there would be an automatic hearing as soon as possible to determine whether it should go adult or juvenile, or
And
youthful offender, I suppose.
does it have to be a violent felony or just any?
My amendment was any felony. They changed it to drug trafficking and human trafficking.
Just drug trafficking,
Huh?
just drug trafficking.
Well, they didn't even do human?
No. So if you look at, I think, does your?
Well, I mean, they took what I offered as a compromise deal to get the thing going. And I said to Martin yesterday that, I'm making it public. I met with him yesterday and I said to him, how can you take a compromise and then offer back something less than I offered? And, they've got us because we've only got 6 legislative days counting today.
Are we really gonna end on the 12th though?
I don't know. And I don't know.
It seems like we're just not ready.
Well, they don't care about these bills, they being speaker. Okay, Eric, enough of my pandering.
Just to confirm though, these cases originate in the family division, the ones that we're talking about in 2A. Okay.
Yeah, the 16-year-old would not have public knowledge of his arrest or her arrest. It would not come unless they were transferred to adult by the court.
right? So it all take place.
So it protects,
Family division.
the argument was, you got kids and they're gonna have a record, blah, blah, blah. Unless the judge determines that, based upon all of those factors, the 13 factors on pages 4 and 5, that this person should be moved to the Superior Court, which then that would become a public record. But if the judge determines that child should stay in family court, or then it's treated as if it was a delinquent act. I thought it was a win-win. And remember, it's only when you're carrying a fire in the commission of a felony.
But does the version you're looking at include Roman numeral subdivision 2, in other words, Roman numeral II, petition alleges that the child carried a dangerous weapon while committing selling a regulated drug?
Yep.
So just so you know, as a technical matter, that subdivision 2, that's the difference between your proposal and what they came back with. They added 2. Other than that, it's exactly the same.
So in any version that we do, we would strike 2.
Yes, either strike it or change it or whatever, but yes, that's the difference. Other than that, they're the same.
Or strike the word selling or trafficking a regulated drug.
Well, then you'd have drug possession, like marijuana possession being swept in. You might not want that. If you just want it to be drug, any felony drug.
Well, no, I want it to be everything.
Oh, in that case, you'd strike the whole 2.
Yeah, that's what I thought.
Yeah.
Any felony and you're carrying a weapon.
That is covered by 1.
So, and this is just potentially my not understanding the way the bill itself weaves together. When we moved S4, we had this sort of exception language that accepted out felonies that were only felonies because of the monetary value associated with them. Does that carry into this part?
That was a separate, that wouldn't affect this, and this wouldn't affect that, because if I remember correctly, that
Did they
was,
leave that section
they made some changes to this last night as well, so let me double check and see if that's.
in? Well, if that section still is not still in, then we need to put that language in here, but I thought that section was still in. Last time I looked at the House bill, it was still in.
Let me double check.
Well, I just, in thinking about this, kind of want to make sure that we're exempting those felonies that are,
Yeah.
through the
No,
window.
that was-
Okay.
that was-
So they struck the whole section. No, that section is still struck. So you don't need that, Senator Duhofsky, actually, because the only reason that distinction was in there was because to say that was remembered for purposes of the bail here.
Right, what I think I'm saying is that
Well,
exemption
we
should
may
also
want
be
that
in
back
here.
in, Eric. I may.
Oh, I see what you mean. If it's all felonies, you
Right.
don't want it to be a felony that's only a felony because of.
Right.
Gotcha.
Right.
Right,
So.
That's why I was wondering if that applied
But I
blanket
want
across the
that, I
bill.
want the language about carrying a firearm back in, that was in our bill. I think we're talking about 2 separate sections.
We are
Yes.
talking about 2 separate sections, and my question was whether
my-
or not that exemption applied to the whole bill, because I think it should apply here too.
I gotta go to S4. Jeez. I wish they'd just do the right thing and pass rubber stamp our bills.
I think if I'm understanding Senator Duhofsky correctly, Senator Sears,
Yeah.
what you might consider doing if you're going to do a counteroffer is that your subdivision lowercase I or Roman numeral 1, that says it applies to all felonies.
Yep, back in the day, it was section 8 of the bill.
That's a separate, right, it was section 8, but that's that separate issue of that separate offense. If you're talking about your provision of when it is this case can be transferred, they have to have a hearing.
Right,
I think what Senator Duhofsky is suggesting is that Roman numeral 1 language where yours says the delinquent act set forth in the petition is carrying a firearm while committing a felony in violation of so-and-so, you'd add language that say, provided that it shall not include a felony that's only a felony because there's more than $900 worth of property. So
an
that,
offense that is a felony rather than a misdemeanor solely because of the monetary value of the property involved and shall not be considered a violent act. Under this
well, you wouldn't include the violent act part because that's a separate issue, but you just exclude it from these.
But no, but if we add back in our section 8 from S4,
Yeah,
Well, Eric
I
is
think
saying
that's a
that's,
separate issue.
yeah, that it has to go in both places, even
Right,
if we add
right.
section 8 back
Okay, but
in.
it has to go back to both places.
Yeah, definitely, you can do it both places. We want to put it here too, if you want to have that same
Alright.
principle apply. If I'm
Let's,
understanding.
let's keep going with their,
Quick question, Eric. Are all the felonies that are listed here on, starting at the bottom of page 1 to page 2, are they technically considered to be violent felonies?
I'm not sure, do you mean for purposes of bail?
Yeah, for purposes of bail, but also just, yeah, for purposes of,
Well, I think it's a fact, whether it's an element of violence in the felony, if I remember the cases on this correctly, it's whether or not it's an element of the offense, I think. But I can look back at that, and I think it's a fact-specific case-by-case determination. I don't know that we have a definition anywhere
I mean,
of
all the big,
violent felonies.
right,
all the Big 12, the one question mark had always been for me anyway, burglary into an occupied dwelling. Whether that's violent or not.
Mhm.
And evidently the legislature back in the 70s deemed it was violent.
yeah,
So that was just for some historical value. When that was added, the case law was that burglary of an occupied dwelling meant exactly what it sounds like, breaking into a home that is occupied, and that was considered highly dangerous because it's an easy way to get yourself shot. There's been case law since this developed that has said that burglary of an occupied dwelling applies whether the dwelling is occupied or not, as long as it's a type of dwelling that may be occupied. So for example, the problem that we run into with that is like kids up in the Northeast Kingdom, 14, 15-year-old kids break into deer camps because there's always bottles of whiskey in the deer camp. And you can, well, seriously, they do that kind of stuff.
believe you.
And it turns into a Big 12 offense and they're charged in adult court because it is technically burglary of an occupied dwelling, even though they know the dwelling is not occupied. They're breaking into it in the middle of the summer, not during deer season. That's been a problem. Our hope had actually been to narrow the Big 12 and specifically that one provision.
Maybe one of the things we could do, we add S4 to some bill, would be in the sentencing committee report, ask them to review not only the new crimes that we asked them to look at, but whether or not number 12 should be part of the Big 12. And whether or not it should be further refined, because I've always felt that just what you just said. I always thought an occupied dwelling meant that somebody was there. Or, you thought somebody was there. And that's much different from breaking into a deer camp, which you know is not occupied. Anyhow, moving right along. So I thought the compromise was often in good spirit. It's unfortunate that they couldn't even accept that. Part of the problem. So commencement of delinquency proceedings, that's all what was in our bill, right?
Yeah,
And then we get to, they took out the knowingly permitting sale. What did they do? They didn't even create that a crime? Oh, okay, I'm sorry, they did it.
Kind of.
5 years or not more than 1,000.
Yes.
It looks like it strikes the landlord piece and just focuses on no person at all.
so this must be, I must have sent the wrong version. Does yours version say that it's 5 years?
Yeah,
It's 2. They went back to the initial.
okay.
I don't know how.
Both-
this got in there.
Both are 5 years. Yeah, but no person. That means every tenant in the building?
What do you-
But is every tenant in the building permitting that, like, that is confusing.
I mean, if you're the person on the lease and you let other people into, I mean, this is the way I'm reading it. If you have control of that apartment and you're the person who's signed the lease, not necessarily the landlord, and you have your friends over.
Yep.
And they're they're engaged and one of them sells another person drugs, does that that puts you on the hook for this? That's what I'm reading. And it seems to kind of just go around the original point, which was to hold landlords accountable. So I have an issue with that as I'm reading it now. I don't know if that was in our
Yeah,
original.
I ran into Chris Loris in the hallway. He was furious that the house was taking it out, the landlord out, because that was the huge problem in Rutland 8 years ago. He was mayor, and the landlords who wouldn't do anything. So I would prefer, if they wanted a misdemeanor 2 years, I'm fine with that. I think the fine should be what we had originally proposed there. But I'd like, in anything we send back to them, I'd like our landlord language.
Can we,
If somebody's permitting the sale or permitting all this stuff going on, they're guilty of a lot of other things. They don't need this one.
yeah, I was about to say, if we can change no person to no landlord or landowner or property
I think
manager,
we
or
just go
whatever.
back to our original language, landlord language.
But your language was person. That's existing law. That's law.
Okay.
So you can change it, but just.
No, but I thought the heading was landlords.
No, it was just penalties for dispensing or selling regulated
Well,
drugs in a dwelling.
we had struck
Okay.
dispensing on,
Correct.
in a floor
No, but
amendment.
Right, right. Penalties for selling regulated drugs. in a
Right.
dwelling.
All
And it
right,
said
you're
no
right.
person shall.
Just go back to our language, but allow them, allow their recklessly language. Just do recklessly. I don't want to argue about knowing,
So in other words, strike recklessly.
strike recklessly. Just knowingly, it'd be knowingly permitting sale of regulated drugs in a dwelling.
And are we gonna compromise and give them 2 years instead of 5?
Yeah, but I want the $15,000 fine that we had at both cases. $1,000 fine doesn't mean a hell of a lot to a landlord.
Just something.
So both on in the human trafficking, it'd be knowingly permitting human trafficking in a dwelling. And on the drugs, it'd be knowingly permitting the sale of regulated drugs in a dwelling.
Oh, no, I'm not sure.
That'd be section 3 and 4 of our bill.
Right.
And make the penalty 2 years and $15,000. And obviously repeal that. That's where the landlord was in the old bill, the old law.
You mean that, yes, the provision of that, the safe harbor for
Yeah,
landlord, yeah.
yeah.
Landlord has the safe harbor, totally, and that's what you want back in.
Right. And then in section 5, they took out the bail. I mean, the violent act on the defacing of firearm serial number.
Yeah, 5 and 6, I believe they took that.
Yeah, I'd like that back in. I think there's good reason to try to stem the flow of these firearms into our communities.
So that goes back in, and those are I think the only changes to those sections that the House made.
Yep.
So that brings you to section 7.
Yeah, that was actually a good pickup by them.
That's A3. You see
Yeah,
this, if the order prohibits the person from
yeah,
possessing a
because
firearm.
you don't want to prohibit the firearms if it didn't. You don't want to make it a crime if the order didn't prohibit firearms.
Fair point.
All right, so leave that in.
Yeah.
Section 8 was the one you were just discussing. Sorry, no, I skipped one there. Wait,
It was our section 8.
yes, your section 8 is gone. That's what I did.
Since it's gone, you can't find it, but if
Right.
that was the while committing a felony,
Yeah,
and that's where the exemption was in that Senator Bahalski was just talking about.
right. So that goes back in. So you're putting that back in, if I'm hearing you right. The bottom of page 12, line 18, you'll see that's where the age 21 was changed to 22 for the.
Yeah, that was a good pick.
And the community violence prevention program in section 10 is, there's not a lot change there. They add on line 14, the Council for Equitable Youth Justice as well. You'll see the language.
I'm fine with all of that.
Okay,
I have,
that was from Susanna Davis, by the way. I just should mention the
Yeah.
line, the
okay,
line 13, or sorry, page 13 language.
and I'm fine with, the effect to repeal the, change, move a year on the, on the 19-year-olds. Which is top of page 16, section 12.
Oh, the raise the age, you mean?
Yeah.
Right. Yeah.
And I'm fine with the plan for secure placement, section 13. On the sentencing commission report, we would add that section on looking at whether or not occupied dwelling should be redefined or should be part of the Big 12 or how they want to. And then there's one other thing, Eric. On attempts. I realize the Defender General says attempts are already covered, but it might be helpful in section 1. Arson causing death as defined in 13 BSA 501 or attempts, or however you draft that, and do it in all 12 cases. So we're not adding attempts to the Big 12, we're just making legislative intent clear that an attempt to murder somebody is a Big 12. Is that something that's doable?
Are you talking about in the Big 12 itself?
No, I'm talking about, well, yes, I'm talking about changing each one of the Big 12 to add attempts to each crime. Is that doable?
So it might read something like arson causing death as defined in 13 BSA 501. Or an attempt to cause that offense.
Yeah.
Are attempts at these crimes charged and like I don't know how to ask the question I'm trying to ask, but if I were in court being charged with attempted murder, would the potential outcome of that case be the same as if I were in court being charged with murder?
Yes.
I think the punishments are the same, right?
Yeah.
They have to prove there was a substantial act. For example, you fired the gun at Marshall, but you were a lousy shot.
Like a step beyond mere preparation.
I believe the language that the court uses as really confusing, but it is the commencement of the consummation of the crime.
Yes, that is very confusing.
Once you cross the boundary of the commencement of the consummation, then you have an attempt.
There was a case at the Windsor prison. I remember talking about it. Absolutely. The case at the Windsor prison where the guy had a saw smuggled in, a hacksaw smuggled in, and was trying to cut the bars, and he was unsuccessful, but it wasn't considered an attempt because he didn't get the bars cut enough, I guess.
That's a really old case, but yeah, that was early 1900s or late 1800s case.
Yeah.
That's a famous one.
Yeah, I'm just trying to think of the potential implications, and I just don't know enough about how the law works.
I think it probably could be done today, but it's giving, remember in the bill that we passed in the Senate, it had attempts to commit a Big 12 as a big, which would have been part of the Big 13 or 14, whatever. And so in that, what I'm looking at is, let's just put it in there. We don't create a new crime.
Mhm.
We already know attempts could be charged, but it just makes it clear to to the courts, the legislative intent and attempts.
So it sounds like it's not really changing current practice,
No.
it's just clarifying.
Then you could strike on page 18, line 20, which is attempt to commit any of the offenses listed in this section.
Right. So presumably, if you could charge someone with the offense, you could charge them with an attempt also, right? And that's why there'd really be no substantive difference.
I thought,
We already are used to dealing with big 12 charge attempt crimes. It happens regularly.
Right,
So from my perspective, this is going to change the law.
right.
I thought that if the crime is completed, you can't simultaneously charge for an attempt because they merge, right? Or does that not?
That's a good point. I don't know the answer. That's a good question.
I thought that's how it applies.
Right.
Yeah.
No,
because
I
if you-
agree with you. I wasn't trying to imply that you could be charged with both the completed crime and the attempt, but you get charged with the crime and the attempt.
Right.
So when you get the information, it says murder, and then under it says, whatever it is, 13 VSA section 9.
Yeah. Nice.
So if you attempt the murder, you still get charged with murder, is what you're saying?
And attempt.
That seems strange.
It is.
We
Just
did
repeat, that
hand
seems
out,
strange.
It does.
we did hand out an email from the state's attorneys who are not able to be here. And I can well, we don't have much time left, but if Marshall has any comments on our potential changes, he's welcome to provide them.
I have a brief comment. So understanding that, of course, I've already testified that we're opposed to some of the changes and stuff that you're putting back in, and I'm not going to rehash that. My one concern is about the new language around the automatic hearing. That is on page 3, starting on line 18 and going on to page 4. And my only concern is that because this is an automatic triggered hearing, it doesn't establish who has a burden of proof. It doesn't establish what happens if, for example, the prosecution and the defense agree that this case should stay in juvenile court. And in fact, it implies that a judge needs to go through these factors and make these findings anyway, even if both parties agree that there's no reason for it to leave juvenile court. So all I would propose is on page 4, on line 13, after subsection capital B, adding a subsection capital C. It just establishes that the state has the burden of proof in the transfer hearing. Because otherwise it's not even clear who's responsible for putting on evidence, for example. If the judge is to make that determination, who puts on the evidence, not the.
Could you cite that again? Sorry, I didn't quite catch that.
So on page 4,
Yep.
my suggestion is to add a subsection capital C under capital B on line 8. That just says that in a hearing triggered by this subdivision, the state shall have the burden of proof.
But so it'd be number 1, there's probable cause to believe the child committed the charged offense. Number 2, public safety and the interest of the community would not be served by treating the child under the provisions of law relating to family division and superior court and delinquent children. And you'd either put a 3 or a C.
I'm thinking above that, which is, I'm on page 4, not on page 5.
I was on page 4.
I might be looking at a different version.
Yeah,
you're
that's
looking
fair.
at.
I'm looking at draft 3.1 if that's 4.
Oh, I'm looking at one that's entitled S4 House Changes to Senate.
Oh, okay, all right,
That's.
all right, well, that's where we're just in a different.
So,
And that would be-
Exactly, page 4, okay.
in fact, you should real quick.
The C is already there, so it'd be a new D, wouldn't it?
Here's That's,
There's an A, B, C.
All right, so it's under D, I see what you're saying.
Aside from,
Are we okay with that?
I have lingering questions that I don't think we'll be able to fit into 10 minutes. Still worth talking about once we go offline or, when we get a chance to chat. I just have some questions, but still trying to think about a few things.
About this section,
Which section are you?
the automatic hearing.
Oh, I thought you were talking about in general. I don't have any questions about the automatic hearing. No.
In general,
In general. Okay.
what, if you'd like to.
Yeah, I think, so for example, page 7, the proceeding,
Version.
3.1, the one that was on our desks.
No, this is what I handed out.
Oh.
This is.
Oh, I've been looking at 3.1 as well.
Me too.
Didn't I just hand out, when we sat down, I handed you guys all house changes.
Yeah, it's 20-page document dated 4/28/53.
Yeah, that's the one that you guys are looking at.
This is the
Oh,
31.
The one I had.
Got it.
But I was looking at, but that's
Oh.
wait a minute.
Did I hand out the wrong one?
I don't know, mine,
This
the
is
draft
the
that we've
miscellaneous.
all been looking at is 3.1,
Yeah,
5/4/23.
Oh, yeah, that's the one that Panina sent me that they printed
Okay.
out yesterday.
okay.
That's great.
Okay,
That is what has to do.
Okay. So page 7.
Sorry.
Yeah, so I mean, and I don't want to open up a can of worms 10 minutes before the floor, but, starting at line 8, was that in our original bill that we sent over? I think that it was.
I missed the question, sorry, well, maybe that wasn't for me, I was.
page 7, line 8.
Any proceeding concerning a child who's alleged to have committed one of the acts after
Right.
14,
Right,
starts in the criminal division. The state's attorney can have it sent to the family division on a motion.
That's a big 12 offense, right?
yeah, that's just a repeat of the language that's right above it, that existing law language 2 through 7, which is the general statement of how generally speaking, big 12 offenses start in the criminal division, provided that there's transfer provisions elsewhere in the chapter, we can file a motion to transfer that. This is just do it, this section is only a way to have violations of conditions of release with respect to a big 12 offense also start in the criminal division.
Oh, okay.
That's
Our version worded it differently, but this does the same thing.
Okay. So all right,
If I might
that makes a
just-
bit more sense.
That I actually got a memo from Eric to try to explain it to myself, which you might share with the committee if you like.
Sure.
Eric did a kind of analysis of the two versions and showed how this section does. Yes, Marshall.
and I would also just add that, one additional reason to not add it to the Big 12 and instead to do it this way. So that what actually happened upstairs with the House of Representatives, they didn't like the idea of, they agreed that it should be in criminal court, but they didn't like the idea of adding it to the Big 12 because it's a misdemeanor, and they just didn't feel like it should be part of that list.
Yeah.
I also then subsequently, after my testimony, realized that there's some other good reasons, which are that there's a couple of statutes that are unrelated to juvenile justice that have started to refer to the Big 12, the same way that we refer to listed crimes in certain places. And so we have to be careful about what we change in the Big 12, because it's not just changing juvenile jurisdiction, it's also changing.
That's, if you would share that memo with Peggy and we can get it printed out for everybody. It was a good explanation because it helped. I had the same concern.
Yeah, okay.
And PCR.
The other concern I have, I mean, so, last night we got a letter, and, it had some research attached to it, which, I wish we had a few months back, but I was able to read into it a bit more this morning. And, I'd like to make sure that it's focused on violent felonies that pose a danger to communities. And so, I'd like to see, if possible, including the word violent on line 7, page 3, instead of just any felony. To make sure that the felony actually has an element of violence in it.
My assumption had been, and I know the email or the letter you're talking about, because that was on the House Judiciary webpage, which I found last week. And it was also an email from the Attorney General. And so what the House did was take all of the additions we made to the Big 12, the 4 additions, put them into the study. And so that was as a response to that, and this doesn't change that.
So the felonies that are included when we're talking about while committing a felony in violation on page 3, line 7, those are felonies that have an element of violence.
Not necessarily, but the element of violence is carrying a firearm. That was my assumption. But I thought that their complaint was it was racist to add to the Big 12 those certain crimes. And we basically concurred with the House to not add those to the Big 12. Other than attempts that we just discussed, but I don't think that's what they were talking about. Also, I looked back when I saw that on the House Judiciary website. I looked back and I looked at our witness list, and we had witnesses from that community. We had Aton, we had other witnesses. So for them to say they only heard about the bill 36 hours ago, I don't know. But I also had a conversation with the Attorney General yesterday about not receiving their email. That it would only been fair to provide that to the House, to the Senate Judiciary. I don't know, Tim or Marshall, do you want to comment on that?
Yeah, but I think my concern with having, I would agree that it should have the word violent in it.
You would or would?
That it should have the word violent, because I'm picturing things like somebody driving home from a hunting trip with a rifle in their trunk.
Yeah.
And they're a little over the limit, and they get their 3rd DUI. That's not, a 3rd DUI with a hunting rifle in the trunk isn't really what we're trying to go after here. And so that's why I would want to include violent, because I agree that violent felonies are what we're trying to get after here. But this is Vermont, people carry guns for reasons that have nothing to do with the commission.
Yeah, right on the state house stuff.
Okay, so Tim, for the record, and I think, yeah, the plain use of the word violent would be, I think, good, rather than, I know we have a twisted version of what violent means. There's a definitional side. I think how we understand the word violent to mean an element of violence would be appropriate, as opposed to trying to tie it to any other enumerated lists in our statute.
Would both of you mind helping Eric with that language?
Yeah.
Fine. And I will add one other thing. Eric reminded me that in terms of the bail, in terms of the defacing of serial numbers and straw purchases, and that being considered a violent offense for purposes of bail, we have 4 other offenses that say shall be considered that are not necessarily violent. Lewd and lascivious, I think it's aggravated domestic assault. They may be violent. They may
That
not.
sure sounds like it would be violent.
Well, it may be or may not, doesn't need to be.
I hate to end our quorum abruptly, but I am presenting here in a few minutes,
Okay.
so for universal school meals, so it would be great if I,
It would be probably good if you were there.
yeah, it would be good if that's,
All right,
That's all
so
right.
we'll, is it okay with the committee if I work with Eric